Hi, this is Meghna. I'll be dealing with performance of contract. The term performance of contract means that both the promisor and the promisee have fulfilled their respective obligations which the contract placed upon them. For example, A visits a stationery shop to buy a calculator. The shopkeeper delivers the calculator and A pays the price. The contract is said to have been discharged by mutual performance. Under this performance of contract, we'll be dealing with free consent. Section 14 of the Indian Contract Act deals with the free consent. Consent is considered to be a free consent when the factors are satisfied, and the factors are coercion, undue influence, fraud, misrepresentation and mistake. And the case law regarding to the free consent is Bala Devi versus Mazumdar. In this case, an illiterate woman executed a deed of gift in favor of her nephew, under the impression that she was executing a deed authorizing her. But the evidence showed that the woman was never intended to execute such a deed or gift, and no one explained about the deed to her. So the court held that the deed was void and inoperative as there is no consent in the deed. And now we'll be discussing each element in detail. And the first one is coercion. According to Section 15 of the Indian Contract Act, coercion is the committing or threatening to commit any act forbidden by the Indian Penal Code, or the unlawful detaining or threatening to detain any property to the prejudice of any person whatsoever with the intention of causing any person enter into an agreement. And the case law regarding to the coercion is Chikkam Sevashamma versus Chikkam Amiraju. In this case, the husband, by a threat of suicide, induced his wife and son to execute a release deed in favor of his brother in respect of a certain properties claimed as their own by the wife and son. Court held that to commit suicide amounted to coercion within the meaning of Section 15 of the Indian Contract Act, and therefore release deed was voidable. And the next one is undue influence. According to Section 16 of the Indian Contract Act, a contract is said to be induced by undue influence, where the will of the party consenting is able to dominate by the other one due to the relationship between them. One party influences the other while the contract is formed to get an unfair advantage over the other. And the case relating to this undue influence is Lakshmi Amma versus T. Narayana. In this case, a person was suffering from a number of ailments which confined him to a nursing home. There he made a deed gifting all his properties to one of his sons to the exclusion of others. Court held that the gift was caused by undue influence, so it is voidable. And the next one is misrepresentation. According to Section 18 of the Indian Contract Act, where the party entered into a contract and the other party commits anything within the intent to deceive, breaches the duty or caused the mistake without having intention, it amounts to the misrepresentation. For example, if we take the case law Bissett versus Wilkinson, in this case it was held that the claimant's statement was nothing more than an opinion as to the capacity of the land based on the claimant's knowledge of farming, together with the defendant's knowledge of the current stock. The statement was not therefore held to be a representation. In any event, the defendant had not been able to demonstrate that the land was not capable of carrying the 2,000 sheep that the claimant had stated, and therefore the claimant's appeal was allowed and the contract could not be resigned. And the next one is fraud. Fraud is a broad legal term referring to dishonest act that intentionally use deception to illegally deprive other person or entity of money, property or legal rights. Section 17 of the Indian Contract Act deals with the fraud. And now we'll be discussing about the case law regarding fraud. Derry versus Peake. In this case, the claim of the shareholders was rejected by the House of Lords. The court held that it was not proven by the shareholders that the director of the company was dishonest in the belief. The court defined fraudulent misrepresentation as a statement known to be a false or a statement made recklessly or carelessly as to the truth of the statement. On the basis, the plaintiff could not claim against the defendant company for deceit. And the next one is mistake. Mistake means misunderstanding between the two parties. So here mistake is divided into two types, that is mistake of law and mistake of fact. And first, mistake of law. Mistake of law is again divided into three types, that is mistake of general country law, mistake of foreign law, and mistake of private law. For example, a person was caught by a traffic police for crossing the traffic lights. The person cannot claim that he is not aware of the rules while traveling and shall be punished. A person must know his own country laws. And the next one is mistake of fact. And again, mistake of fact is also divided into two types, that is unilateral mistake and bilateral mistake. Section 21 of the Indian Contract Act deals with this unilateral mistake and bilateral mistake. And the case laws regarding the unilateral mistake is Tapline versus Janey. The buyer at an auction bought a property described with reference to a plan. The buyer was under the assumption that he was well versed with the property and therefore did not refer to the plan. Later he discovered that a garden plot which he thought was part of the property was not in fact included in the plan. It was held that the buyer cannot revoke the contract on the grounds of unilateral mistake made by him and was bound by the contract. And the next one is bilateral mistake, and the case law regarding to the bilateral mistake is Galloway versus Galloway. In this case, a man and woman believed that they were married and therefore made a separation agreement. But it was later discovered that the man's first wife was alive. It was held that the separation agreement was void as it had been entered into on the basis of the common assumption that the parties were married to each other. And now we'll discuss about the unlawful consideration and object. And the circumstances which would make a consideration as well as an object of an agreement unlawful consideration and object are discussed under forbidden by law, defeat the purpose of provision of any law, fraudulent, injurious to the person or property, immoral, agreement opposed to public policy. And now we'll be discussing the first one, that is forbidden by law, where the object or the consideration of an agreement is the performance of an act which is forbidden by law. The agreement is void. Acts or undertaking forbidden by law are those punishable under any statutes as well as those prohibited by special legislations of Parliament and state legislations. For example, A promises B to drop a prosecution which he instituted against B, while B promises to restore the value of the things taken. It is regarding the robbery, so the agreement is void as the object itself is unlawful. And one more example is where a loan was granted to a guardian of a minor to arrange the minor's marriage has been held to be contrary to the enactment Child Marriage Restraint Act, and therefore here it is void. Therefore money advanced cannot be recovered. And the second one is defeat the purpose of provision of any law. Though the object and the consideration for agreement sometimes not directly forbidden by law, they are still forbidden if the nature defeats the purpose of provision of law. Agreement with such an object or consideration is void. And the next one is fraudulent. An agreement, the object of which is defraud others, is void. When the parties agree to practice a fraud on a third person, not a party to the contract, their agreement is unlawful and void. And next one is injurious to person or property. Any agreement that employs or involves injury to a person or other's property, it is deemed unlawful and therefore void. For example, if a person borrowed ₹100 and in consideration executed a bond in favor of the lender, also the plaintiff in the case, the person in the bond promised to work for him 2 years, failing which he agreed to pay exorbitant rate of interest and the principal amount at once. It was held that the contract was void since the promise contained in the bond was tantamount to a person as well as illegal. And the next one is immoral. If the object or consideration of an agreement is opposed to morality, then it is void. For example, agreements based on immorality, like A is a landlord, let his house on rent to B, a commercial sex worker, knowing that it would be used for immoral trafficking. The landlord cannot recover the rent. Here, the object being immoral, the agreement to pay rent is void. And one more example is A agrees to let her daughter to B as a concubine. The agreement is void because it is immoral, though the letting may be punishable under the Indian Penal Code. And the next one is agreement opposed to public policy. The term public policy in a wider sense means restriction of freedom of persons from doing something in the larger interest for the good of community. In the context of Indian Contract Act, it restricts the freedom of persons to contract in certain areas which are determinal to public policy. So, the doctrine of public policy covers trading with an alien enemy, interference with administration of justice, marriage brokerage arrangements, trafficking in public policy, unfair or unreasonable dealings. The ordinary function of the court is to rely on the well-settled heads of public policy and to apply them to the varying situations. For example, A, the manager of a firm, agrees to pass a contract to B if the latter pays a sum of 5,000 to the former privately. The agreement stands to create interest against obligation and is void on the grounds of trafficking in public offices. Thank you.